Hello, can you hear me?
Hello, yes.
Thank you. Hello, Kun Charlie.
Hello, can you hear me as well?
Yes, I can.
Excellent.
Kun Benyapang?
Yes,
Did you get my slides?
yes,
Okay, very good. And
Okay.
will Kun Charlie be the one doing the introduction?
yes.
Okay. Thank
And
you.
for your slide, I will control it, right?
Yes, correct.
Okay.
Okay.
ลองดู ดีขึ้นมาแล้วเจ๊งไหน
Hello, everyone. Welcome to all attendees to this online webinar organized by the THAC. I'm Charlie Garnjana-Goonchorn. I am a counselor here at the Ministry of Foreign Affairs of Thailand, the Department of Treaties. Oh, excellent. We have all the panelists here. Okay, excellent. Okay. So I'm your moderator for today. Just a brief word of introduction. So today is part of series 1, which the topic is ODR, or Online Dispute Resolution, the future of ADR, Alternative Dispute Resolution. Now, I think personally this is a very timely topic on which we should talk about. Recently, with the COVID-19 pandemic, people have been pressed to go online on many things. My children at the moment we speak are doing school online. I have been shopping online, working online, doing everything online. So the question is, why not dispute resolution online? So is ODR the future? I think so personally, but ODR is not without its challenges. There are things that are not the same as the physical world. We here in Thailand have legal hurdles on ODR from the usual track of doing dispute resolution. So we are here to discuss the topic today and to see what perspectives we can gain from our very prominent panelists here today. Let me take this opportunity to introduce you to all of them. First up, we have Mr. Simon Boehme. I'm sorry if I pronounced that incorrectly. He's a legal tech expert, a mediator and entrepreneur. He specializes in dispute resolution and legal innovation. He most recently served as the head of operations and chief of staff, trust and safety at Lime. Among his other experiences, he was also appointed to serve on the State Bar of California's Access to Innovation of Legal Services Task Force. Simon was also appointed by the Obama administration to serve on the US Department of Education's National Advisory Committee for Institutional Quality and Integrity. Second, we have Ms. Asha Hemrajani. She's the founder and CEO of Visio Clara Tech, which is a niche technology consulting firm. She is a true technologist and a dispute resolution professional with over 23 years of delivering business-to-business market development and customer engagement. She is the former member of the board of directors of the Internet Corporation of Assigned Names and Numbers, or ICANN. Thirdly, we have Mr. Adiya Shivkumar. He's the co-founder of Resolve Disputes Online, or RDO, which is a platform that pioneers in state-of-the-art dispute resolution technology. Who developed the state-of-the-art online dispute resolution solutions for courts, tribunals, companies, mediators, and arbitrators. So, having said that, I would like to hand the floor first to Simon to say a few words on ODR and how he sees ODR developing. Thank you.
Wonderful. Can you hear me okay? Excellent. I am going to share my screen. I'm going to be presenting. Oh, I guess screen sharing is disabled. That's okay. But I am so excited to be here. I am in the heart of Silicon Valley. I'm in San Francisco. It is about 1 a.m. here. I've had my cup of coffee and really excited to be with you. Of course, I wish I could be with all of you in person, preferably in Bangkok. But unfortunately, given the politics here and everything going on with COVID-19, it has been a very bittersweet moment. And ever since COVID-19 has started, I like to start off my talks by saying exactly the moment that we are in is very bittersweet. I have been in online dispute resolution for about a decade. I've been doing online mediations. I've helped to develop online dispute resolution systems. And it's bittersweet because I am so happy that we are talking about ODR and we are talking about the role that mediators and arbitrators can play in ensuring that ODR is the future. But it's bittersweet because it comes at such a in the middle of a pandemic when people are dying, people are getting seriously sick, and that people are experiencing severe economic hardship. So while I am excited about this, I don't want to forget that we are in the middle of a pandemic and we are dealing with these serious things. So I'm going to jump right into it. A little bit about me. I'm a mediator. I also train mediators, arbitrators, dispute resolution practitioners in online dispute resolution. I've been researching and working in online dispute resolution for the past decade. I've started 2 companies where we've tried to resolve and help people resolve their disputes. The first one was Magnify, where we summarize the fine print and help people navigate going through customer support, understanding that they have certain rights when they buy products. And the second one was Legal Win and Disputely, that helps people to resolve their disputes online. And so now I've been advising multiple legal tech companies, and most recently served on a task force from the State Bar of California, where we've started to change rules to make it possible for ODR and others to really explore the potential of reaching more customers and providing more access to justice. So last year I was honored and delighted to speak at the Thailand Arbitration Center's conference in Bangkok. And last year I talked about crypto and smart contracts, which I still believe is within the realm and the future of online dispute resolution. The ability for the automation of executing certain kinds of transactions. And if there are disputes within those interactions and those transactions, so for example, United Airlines or Singapore Airlines orders X amount of parts from Boeing or Airbus, and some of the parts don't show up, some of those disputes can be resolved automatically. But today what I want to talk about is and explain to you how we can continue this momentum of online dispute resolution because of COVID-19, how we can continue to ensure that it is a part of the future. I believe ODR is not the future, that it is already here. And now that everyone here on this webinar has a role to play into making sure that it could be the right solution for many people's disputes, that we're following the ethical guidelines, and that there's a basic level of technical competency. So I think one of the most important things that mediators and arbitrators across the world can do is to most importantly seize this opportunity. Those that can seize this opportunity will be able to have a competitive advantage. Already when we start to look at the restrictions on travel, the time that it may take to develop a vaccine, the uncertain political influences, and just kind of looking at the entire situation, online is here to stay. And when you are able to have an expertise in being able to mediate and arbitrate online, that is going to be able to separate you from some of your peers. And for companies that are looking to shave costs when it comes to legal fees, your ability to offer this online is going to be really powerful. And I know Aditi and resolve disputes online, and I hope he talks about it, but there's going to be some really incredible software and offerings out there. And I'm going to jump into that a little bit later. But I think one of the most important things that we can do within our dispute resolution community is convince others to get online. And one of the biggest pieces of feedback I've received from lawyers and clients is that it's not secure to conduct a mediation or arbitration online. So let's just take a moment and step back from that. What does it mean to have a secure conversation, and what does security mean? So first of all, Zoom, rightfully so, was under a great deal of scrutiny for some of its lack of attention to security. But over the past 60 to 90 days since COVID-19, at least in the United States, really became aggressive and people were sheltering in place, Zoom has done a tremendous job of ensuring the security of lawyers wishing to conduct mediation arbitrations online. And I think it's also just important when you're explaining to clients and you're explaining to others is that everything is hackable. An in-person mediation can still have a malicious actor that brings in their cell phone and records what's going on. In the same vein, you can have someone record the entire mediation. And obviously there are steps that you can take as the mediator or arbitrator to protect your convening. The very first thing you do is you say, I need every lawyer, I need every participant to verify that he or she is not recording. You also have that in the confidentiality agreement. You have that written down and you have that. Now I understand, and in the United States, particularly, that's just what I'm most familiar with, this is becoming an issue. Because there are, mediation has gone online and they involve participants in multiple jurisdictions, multiple states, you have to be very careful about which state's confidentiality privilege law that you should use. So that's just something to keep in mind. And again, these are the kinds of things that require a certain level of technical competency and being able to keep up with the developments in the online world. And I think that's really important, is that online dispute resolution is not something that's static. It is not something that is the time-honored tradition of an in-person mediation or arbitration. When I'm a mediator and I know, the conference room I'm going to go in where the plaintiffs are on one side, the defendants are on the other side, it's very easy to navigate. But that online dispute resolution does require a little bit more work. And I love Charlie's introduction around it. There are hurdles to successfully navigating online dispute resolution, but the success and the trade-off is tremendous. And again, I train a lot of mediators, arbitrators. I can provide my email as well. I'm happy to navigate and answer people's questions as it applies to Zoom or some of these other platforms. Something else that is really important about online dispute resolution is I believe that there has to be an ethical obligation to have a backup or use new platforms that are designed specifically for mediators or arbitrators. One of the best examples is Resolve Disputes Online. We have the co-founder on the call right here. When you have that level of intimacy with the co-founder and you're able to provide feedback and you have access to his email, that's a really powerful mechanism to how you can provide feedback. And this is really critical. When there's a different feedback loop between the law and technology. Technologists want you to, oh, terrific, there's my, my deck right there. Technologists want your, yeah, this is perfect right here. Thank you. Yep, great. We just keep it right there. So for example, Resolve Disputes Online, you want to be able to have a feedback loop, and technology wants to just make tools that please the customer. And the law has a very different kind of feedback loop. There's ethical obligations, there's a due process, there's certain kinds of fair, different procedures that need to be followed. But in technology, it's all about how can you make the customer happy. And that's why I've been encouraging people to maybe explore something like Legaler, something like Modron, something like Crick RDO. So, and Resolve Disputes Online. These are 4 alternative tools that target lawyers, that target mediators and arbitrators, and they make the process better. And to me, that's really powerful. So for example, Legaler, they have a much better mechanism for breakout rooms than other people do. And right now they're offering it for free for 12 months. It's legal and then at er.com, so legaler.com. Another great one, Modron. It's called these Modron spaces. You can have separate caucus rooms for everyone. They have different abilities for video sharing, and it's very secure. That's the great thing about Resolve Disputes Online, Crick RDO, CREKODR.com. A lot of these tools are just 10 times so much safer than Zoom. And so when you do have pushback from clients saying, hey, you know, we really just don't get online because we don't trust it. Well, first of all, if you're using email, you know, that's certainly not the safest thing to do. But, you know, explain to them that you also know how to have a mediation or an arbitration using some of these other platforms. And it's at a good cost, and it's easy to onboard those people. Again, I'm very happy to answer these questions, or I'm happy to do a screen share and I can walk you through some of these as an example. I think another way, a really practical way for some of us to become even more advanced and how we can bring the future into today is we understand how to put some other services online. So for example, DocuSign or Adobe Sign. Of course, there are some jurisdictions that require a wet signature, but if you use DocuSign, a really powerful tool, again, can get a signature on an important document faster, even if it's just the confidentiality agreement, it's the mediation rules of the road. And so that can be really powerful. Again, I think you should try to the extent that you can, email is not the most secure way of communicating with people. If you do want to send documents securely, consider using Dropbox, consider using Google Drive. So those are the kinds of things that I would really encourage you to think about that can assert yourself as an expert in online dispute resolution, because it is now here to stay. And I think that's the really key takeaway, is that when we as a community work together and we exchange these ideas, that's how we can continue to maintain and propel online dispute resolution to move forward. It requires technical training. It requires, you know, ongoing professional development in that kind of way. And it's also learning how to use new tools. And to me, that's really exciting. So when we go to the next slide, what is a trend that is starting to emerge is how are corporations, how are court systems starting to use online dispute resolution. And to further, I think, at least prove my thesis that ODR is here and, you know, the future is here. The real question that people are starting to ask is, how do we build a 21st century version of justice without replicating an outdated and inefficient model, especially when it comes to certain court processes? And it starts with ADR. It starts with alternative dispute resolution paired with online dispute resolution. Mediation and arbitration continues to prove its worth and that it is one of the best carriers of justice. And that's why I love speaking in front of people, mediators, arbitrators, solicitors, is because you all are the ones that are making our justice system run. And so prepare yourselves for more automation, especially in smaller dollar cases. So I'm from a funny place called Kalamazoo, Michigan, a very small, this is the state of Michigan, Kalamazoo's right there. If you've ever been, please let me know. It's a small city, 90,000 people. And the state of Michigan has been super progressive in enabling family mediation and small claims, so any claim less than $10,000. And those processes are online. They work with a local mediation center. We're already starting to see companies like Geico agreeing to have a ton of their insurance. Geico is a major insurance company here in the United States, already having almost all of their, many of their cases for mediation online and agreeing to that. Many of the Oregon State Supreme Court, in Texas has been a leader in some of these online cases. And so start to look out for how your role may also be asked to change when you are dealing with larger corporations or court systems, and how technology is going to play a role in that. And so I think what is really exciting is that it is mediation and arbitration can lead the way in driving faster, fairer, better solutions to parties. And technology can be the bridge and not the divider. And I mean, ultimately, this expands the pie and the ability for us to reach more customers, for us to resolve more disputes and resolve them more efficiently. When people ask me, when I'm online, should I be charging less as a mediator arbitrator? I oftentimes say, you should be charging more. Because for you to have the expertise to navigate and resolving a dispute online requires a greater knowledge and greater skill set. So to me, and I'm not sure how I'm doing on time, Charlie, so I can wrap it up right here. But to me, and if you want to just go to the next slide, essentially, if you have any questions, feel free to email me, follow me on Twitter. If you're interested in advancing your Zoom skills, my deck is free. It's odrzoom.com. You can access it. I can send you the deck. But learn how to use Zoom. Learn how to use Legaler. Get resolved disputes online, Modron, and seize this opportunity to help your firm to have this competitive advantage. Because as I believe, and I've been in this for 10 years, I'm just so excited. I hope it's here to stay. And I think the most important thing is just stay online, convince your clients to get online. And if they don't want to get online, that's okay. Maybe at some point they will want to get online, but use technology as a tool in your toolbox. And that's really most important. So Charlie, I think I'm over on time. Sorry about that, but I love online dispute resolution and I'm super excited to answer all of your questions.
Thank you very much, Simon. I think you bring up some very good points there. Certainly in Thailand here, I was discussing ODR with friends at the Thai courts also the other day, and he was saying that, this is the, for the Thai court system, which is traditionally quite a conservative system. They were saying this is the prime time to adopt ODR because nothing is going to force us onto ODR more than the COVID-19, Exactly. And the question is, how do we stay in ODR once the pandemic goes away? Because, you don't want to hop on the train and then the COVID goes away and then everyone stops and goes back to doing whatever they're doing before the pandemic. So this is a very, 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 very useful comment. And I think you really struck the nail on the head. And also,
if I can just say one thing, I think it is two driving forces. It's the community, it's the justices, it's the judges, it's the mediators, arbitrators, but the lawyers and the clients and the customers will also realize how great it can be. And I think those two forces can make ODR sustain and propel. So I'll leave it at that.
Yes, I quite agree. And, also on that point, for the practitioners, like me, an in-house lawyer at the government, we are more of a conservative bunch where we do arbitration and everything through the traditional way. And, you have to break free of that mold somehow, but it's, we're not too confident on how to do it and, whether it's secure, whether, what's appropriate level of security, so these are real questions which we face every day. So thank you for raising those questions. So we better move on. Next on the panelist, I have Ms. Asha, who will also speak on another perspective of ODR. Please, you have the floor.
Thank you, Kun Charlie. So, Kun Penyapa, could you share the slides, please? Kun Penyapa, are you there? Maybe I'll get started first while she's, okay, here we go. So first of all, I wanted to say hello to everyone, and I also wanted to thank the Thailand Arbitration Center for inviting me to speak today. I'm really privileged to speak with fellow panelists here who are all experienced in this area, and also so many of you some of your names I recognize. Many of you are from mediation and arbitration service providers, and also or practicing mediators and arbitrators yourself. So, I'm very grateful for this opportunity to speak with you today. So maybe we can just go to the next slide. So just a quick introduction. My name is, maybe if you could make the slide a little bit smaller, that would be great. A bit smaller. some more. So my name is Asha Hemrajani, and a quick background. I'm from Hong Kong. I speak Chinese and I speak Cantonese and Mandarin, and I know there's many of you in this audience today who's from Hong Kong, so a big hello to you. And I split my time between Hong Kong and Singapore. I'm from, my background is in technology, similar to Simon's background. I've spent more than 20 years in tech. With a background in telecoms, in cybersecurity, cloud, smart contracts, and blockchain. I've also been doing, as a result of my work in technology and in telecoms rather, I got involved about 13, 14 years ago in a very difficult situation legally. So the project that I was working on, ended up into a legal dispute. And that's when I found out what mediation was. I thought it was meditation. I didn't understand the difference at the time. And, but actually, mediation is a form of meditation. So I've been doing mediations now for about 6-7 years, and I've been doing online mediations for 1.5 to 2 years. And I have to say that in my work in online mediation, I have encountered quite a bit of resistance to ODR, which Simon alluded to. So I'll speak a little bit more about that later in my presentation. I also wanted to explain a little bit about, so my company, I run a company called visioclara.tech, and we do work in cybersecurity and technology. And I've been on the board of directors for ICANN, which is the global domain names regulator. And that regulator has also has had to do a lot of work in dispute resolution for domain names. So when I spend my time on the board of ICANN, I found out that, that it made me realize my work in dispute resolution is so meaningful. And it made me more interested in online dispute resolution because it is a form of another way of using the internet that ICANN really is responsible for. So perhaps we can go to the next slide, please. So Kunchali just alluded to this, what's a new normal? So COVID-19 has really changed the world for us. There was online dispute resolution had started long before COVID came along. I would say actually there's literature about ODR maybe from 10, 15 years ago. And there has been online arbitrations, there has been online mediations for quite some years, but it hasn't quite taken off. But COVID, I think, has been a game changer. It's forced us to reduce face-to-face contact. And the focus now, let's start from the courts. So there are now virtual court hearings, there is virtual alternative dispute resolution sessions or hearings. And at least from an administration perspective, a lot of that has gone paperless. So courts for example, where I'm based right now in Singapore, as well as Hong Kong, where I'm from, the number of cases in person have come to zero or practically, zero or none. And this is during the lockdown period. And virtual hearings, have taken over in many situations. I'll give you an example later on about what happened in Singapore. So in Singapore, the first Apex Court decision was handed out over a video conferencing system, and I'll show you that on the next slide. And you may have heard, then after that, yes, this one here. So there was an acquittal via virtual hearing. This 27-year-old man who was originally handed out the death sentence, but he escaped the gallows. And on April 23rd this year, the panel of Court of Appeal judges decided that he would be acquitted. So that decision was given over a video conferencing system. And subsequent to this, there was a death sentence handed out over Zoom. And I think Singapore was the second country in the world that has handed out a death sentence over a video conferencing system. So there are issues around whether this is ethical. There are lots of different people with different views. I don't really want to get into that right now. I'm just talking about the trends, and I'm talking about what's happening. So coming back to what's happening in terms of virtual hearings, I talked about courts. Now let's talk about ADR providers. So a lot of them have partially closed their offices, and a lot of in-person hearings have mostly been suspended. But virtual hearings have not been suspended. Virtual hearings are continuing or taking off. So I'm actually on a mediator with the State Courts of Singapore, and I've stopped all my in-person mediations, but my virtual mediations have continued. In fact, I've done more virtual mediations during this period than I have before. And the reasons are quite obvious. In Hong Kong, same thing. The pandemic forces in Hong Kong courts have forced the courts in Hong Kong to speed up using technology for hearings via video conferencing. So you see Hong Kong, even though a little bit behind, you see them finally embracing technology after years of lagging behind other judiciaries. And this was reported in the South China Morning Post. So maybe we can move on to the next slide, please. So what are some of the benefits of online dispute resolution? Whether or not this is during COVID or not during COVID, most of these benefits apply either way. Let's take, for example, mediation. What is mediation? Mediation helps parties take a step back, reassess their interests, and find creative or practical solutions to move forward. So nothing that I have just described, it cannot be done online. There's nothing that in what I've just described, it cannot be, is mandated that it has to be done face-to-face. And how does ODR work? ODR, to me, very simply put, is a combination of case administration and virtual hearing or sessions. So the process is, there is a filing of the case, and e-filing is very common now. Irrespective of COVID or not COVID, you can e-file. Selection of arbitrators or mediators, again, can be done online. Document and evidence uploading, again, should be done online because we want to go towards a paperless society. So all the three that I've described, the processes, the first three parts of the processes I've just described can be done online and should be done online. Then the mediation session or the arbitration hearing. A lot of them, if parties are overseas, and it's not convenient to arrange for them to travel on time, many of them have been done via telephone, via video conferencing, and then finally the award or the mediation settlement. So a lot of the processes, whether irrespective of COVID, can be done online and should be done online. Now the question is whether or not the actual process, the actual hearing or the hearing or the mediation session should be done via video conferencing. And I would argue, just like Simon did, that it should for multiple reasons. And these are the benefits I wanted to talk about. One is contactless. It is, ODR is safe because there is less contact. You're not in the same physical room. You're less likely to get infected by anybody. It is faster. It is easier to do scheduling because it's much more, it's easier to get parties to agree to a fixed date, a fixed location, instead of getting parties to agree to a fixed location on a fixed date. It's easier to schedule. There's no need to wear masks. Everybody says, all right, when the lockdown ends and people start going to court again, we can start having face-to-face arbitrations and mediations, but you'll be wearing masks. And it's very tiring to be sitting in a mediation or arbitration with a mask all day long for 8 to 10 hours and speaking through it. So you don't have to do that if it's online. Time savings and venue savings. You don't have to rent an expensive room. Arbitration centers are notorious for the very high rates that they charge. And this is a cost that you can avoid. So these are the benefits. Some of them are very straightforward and very obvious, but some of them may not be so. But I do caution, and I do highly recommend that any ODR system that you choose as a service provider must be a managed system. There are, some service providers that I've come across who say, well, I don't mind. I would just let the arbitrator or the mediator choose their own platform and run the show themselves. And that to me is very risky. So even though Zoom may have improved their security, as was mentioned earlier, because I work in cybersecurity, I know that there are still a lot more cybersecurity issues that they haven't fixed. or there are other cybersecurity issues that are yet to come up. So there are still some areas. So I would strongly suggest that if a mediator or an arbitrator is doing that ODR session, they just should do it under the control of or the auspices of the service provider, and not run the show themselves. It's better the system that is selected is managed. And maybe we can go to the next slide. So I sit on the advisory board of a US organization called ARS. And they stand for, ARS stands for Arbitration Resolution System. So just like some of the platform, I think Simon, you mentioned 4 or 5, ARS is yet another one. Maybe Benyapa, could you change to the next slide, please? So ARS is yet another one, and they're an example, just like the one Modra, just like Legaler. They're an example. They're examples of platforms that service providers can manage. So there are many tools available, but whichever one you choose, I would strongly suggest that the service provider must manage it and must test it thoroughly. There must be a clear test plan. There must be pilots done. I've used several platforms which were quite unstable with software bugs, which can be a bit turn off to arbitrators and mediators. So I would really recommend that ADR service providers should properly test the tool, make sure that there's clear service level agreements with the vendor, and insist the vendor should fix these software bugs in a short time. If you can go to the next slide, please. So ARS is a web-based service provider, and everything's on the cloud. So they automate the process from uploading the media to, from multiple devices. You can upload documents and evidence from your phone, from your iPad, from your computer. It also includes the selection. The process also includes, the tool rather, also includes the functionality to allow you to choose arbitrators and mediators from the panel, and of course then the virtual hearing or session. So ARS, the platform has already handled more than 200 cases. Aggregate of claims has been several tens of millions of US dollars, and the average size of dispute has been $72,000 US per dispute. And the area that has covered has been across multiple sectors such as food and beverage, construction, energy, entertainment, retail, and investment. So I've been asked this question. The reason I added this point is because I've been asked this question quite a bit about whether ODR is suitable only for one or two disputes in one or two sectors. And I haven't found any restriction really. I also haven't, the ODR tends to, the disputes that have been handled on ODR platforms so far tend to be of a smaller quantum. But again, I don't see any issue with that expanding to larger quantum disputes. I think it's only natural if there are cross-border or inter-country disputes. ODR would be a natural progression. And but of course, like I mentioned, it's so much very important that the system be managed well, and because you don't want there to be any incident that would create this lack of confidence in ODR. Maybe we can go to the next slide, please. So what, like Kunchali mentioned, what happens after the pandemic? Do we go back to the old system? What will happen after if there's a vaccine tomorrow? What will happen? There will be, and we've already seen this, a gradual reopening of the courts and physical ADR service providers. We've seen that to some degree, not everywhere. Some practices may go back to normal after the pandemic, the crisis passes, but I'm quite sure that 100% return to so-called normal for bricks and mortar cases, at least for the administration side, at least for the first 3 steps that I mentioned, will not. They will definitely move online and stay online. And I also believe that, and I hope that more and more cases will stay online, meaning the entire process will stay online, including the virtual session. Will the resistance to ODR continue to fade? It has been fading, and I think it will continue to fade simply because there are so many benefits of ODR that will be prevalent irrespective of whether or not COVID is around. So there's some of the excuses I've heard is that, I want to see their face, or the case is too complicated to be done online. These were all our excuses that were forced to disappear because of COVID. The question then is, will they come back? Because this yearning that we all have, humans all have this yearning for face-to-face contact. The question then is, will this yearning overpower the progress we've made to move things online? I have a feeling not entirely. For instance, one area to look into is the older and immunity vulnerable arbitrators and mediators. Would they really want to go back? If there are vulnerable people in the community and amongst parties, would they necessarily want to be in a room and for 10, 12, 14 hours in a day? Would they prefer, to be in a virtual environment where they can be safe? So that's one aspect here. The other aspect that was alluded to earlier is there are a lot of things that can go wrong with ODR, and people are worried about, for instance, the ability or the possibility for witness coaching, for cheating, and things like that. There's definitely a need for ODR governance and framework and rules, something that I'm doing research on. And this is a topic in and of itself. It's a 3-hour presentation in and of itself. So I don't want to talk too much about this. One of the areas that has great interest to me is, of course, cybersecurity. So cybersecurity and ethical concerns are very important. Ethics concerns could be, for example, that somebody off camera would be carrying a cue card. And so, the way to handle that is not just have a good system, which is software which you've tested, but also making sure that you have a good process in place, a good governance framework in place. And that's got nothing to do with the platform. That really has to do with the service provider putting together a good structure. The SOL protocol on video conferencing that came out in March 2020 covers some items, covers things like witness examination, venue, observers, document handling, technical handling, and so on, but it doesn't cover everything. Cybersecurity, I'll talk a little bit more in the next slide, but there are some, and I actually do work in this area, so any of you, you're more than welcome to contact me. And if you need any advice on or help on building this governance framework. So let's move on to the next slide. For cybersecurity, like I mentioned, that's something of personal great interest to me. So I have this pretty rare combination of being a mediator and in tech, which of course Simon is as well, but I also do a lot of work in cybersecurity. And one of the things I do is I advise SMEs and I advise ADR service providers on how to best implement cybersecurity protocols and any further protections they may need or they may wish to consider. A lot of precautions and measures are plain common sense, right? There's no excuse not to deploy these cyber hygiene measures. You need that proper governance framework, you need the protocol, you need the cybersecurity measures that may not come with your platform, but you have to do as a matter of doing it as a matter of a proper process in your organization. Why is that so important? Because ADR involves digital exchange of information. Whether this is a physical ADR or an online ADR, there will be digital exchange of information. So as a service provider, you have to protect your information. Because why? Look at some of the examples I've listed out here on the slide. If there's a breach, that information then can be abused by a hacker. And that can lead again to economic loss and reputational loss, which can be quite disastrous. For instance, in an arbitration, the arbitration hearing could be hacked, proceedings could be made public. In a mediation, a private caucus could be mistakenly made open. So I'm not trying to scare everyone away from ODR. On the contrary, I'm saying these are areas that can be handled if there is a proper governance framework in mind, and if you have deployed proper cyber hygiene measures. Simple things like, for example, not using the camera on your computer, but using this kind of camera, which can rotate 360 degrees to make sure there's nobody else in the room. These are basic common sense things that should be done in order to deploy ODR properly and raise the confidence level. So with that, I think I've wanted to bring my comments to a close, and I'm happy to take any questions. Thank you very much.
Thank you very much. Sorry, thank you very much, Asha, for that presentation. Also bring up very, very useful observations. I particularly enjoyed the dissection of the various stages of the court system for ODR. Thailand's not quite as far forward as Singapore yet. We're starting to do e-filings and that sort of thing, but the online judgments, I think those are waiting to come. Thank you also very much for highlighting the cybersecurity issues. You now make me more realize there are more issues that we have to be concerned with. So we also take care of those in the future. But I have a few questions for you, but we'll leave those to the Q&A. Before we go to the Q&A, we have one more panelist, which is Adiya. You have the floor, sir.
Thank you so much, Kanchali, Kun Benyapa, the organizers of this conference. The speakers before me have given me a very tough ask. They've in fact completed all my points that I wanted to speak in this webinar. So both my good friends Simon and Asha have done exceedingly well in addressing some of the key issues. But there was something more simpler that I wanted to touch base today. Today marks a very important day in the history of the world of dispute resolution. For the first time in our history, we are witnessing a pandemic of this magnitude. A pandemic of this magnitude has led to a digital transformation. Last year, Simon and I were in person in Bangkok, speaking before this very same audience on a very similar topic. Today, Thailand Arbitration Center has taken the lead for innovation. It has taken the lead for digital transformation. And because of taking such a lead, we are here for an ODR webinar. Now the topic could be tweaked a bit. Because of the digital transformation journey of, say, Thailand Arbitration Center and all the other centers that have joined together, is ODR the present? And is Justice 2.0 the future? Because ODR is here to stay. We are, like Asha mentioned in her comments earlier, we have been practicing ODR for quite some time over the last 3 to 4 years. Today, COVID-19 has ushered in that urgency. The removal of barriers of trade, removals of barriers of distances, removal of barriers of business. Today, people are very keen to understand how can they do more by sitting in the comfort of their own house. Over the last 4 months, I've witnessed something very impressive. I was able to get a lot more work done sitting in the comfort of my own space without having going to office. Now, why do I say that? Online dispute resolution is something that's very fundamental to the dispute resolution movement. It is something that is very intrinsic to the dispute resolution movement. We speak about the new normal and the old normal. Now, ODR is nothing but a hybrid of the new normal and the old normal together. We live in an ecosystem where there is that interaction, that fusion between technology and face-to-face ecosystem. We've always believed that a face-to-face ecosystem, be it a mediation or arbitration, goes a long way in cementing ties between parties to a dispute. However, in recent times, we've understood, and more so recently over the last 2-3 months, the online platform is your go-to medium. Across various courts in the world, if you take the examples in the United States of America, you've got traffic courts that truly believe in an online dispute resolution mechanism. You don't have to have a day of trial in the court. You look at India, the country that I come from. COVID-19 has played a pivotal role. While I may not like to say this openly, but COVID-19 is a blessing in disguise for the online dispute resolution world. Why? Because people are looking towards technology. People are wanting innovation. People want to embrace change. And if people embrace change, you will have a mindset shift. Now in India, I can speak about some examples in India. We've had the Supreme Court of India formulate an e-committee. Now this e-committee is responsible for all the virtual court architecture of the country. We've got contentious litigations being resolved by online dispute mechanisms. In fact, last week, I had the opportunity to appear in 2 different matters in 2 different courts on a singular Zoom application. Now, this is digital transformation. I was able to appear in one high court of one state and another high court of another state, just wearing 2 hats. This wouldn't have been possible had it been the old normal. The new normal has provided that impetus to change, that impetus to move forward. And when it comes to systems, I think Simon very beautifully had explained about the various systems that are in place and the cybersecurity issues that are all around the ecosystem. Asha had also touched upon it in her discussion some time back. But I truly believe that security is something that is absolutely fundamental. We look at technologies around the world. We look at Zoom, which had some issues of leakages in cybersecurity. No technology is safe. Everything can be hacked. No technology is foolproof. But we have to have a leap of faith towards technology. We have to believe that technology and innovation are our 2 friends in this journey. Unless we believe that, no digital transformation would be 100%. Having said that, if I'm a practitioner, I'm an ADR practitioner, how do I view technology? Do I view it as a threat? I don't. I frankly don't view it as a threat because I'm able to do a lot more work. I could sit in a remote island of the coast of Southeast Asia and still do arbitrations and mediations of various other ADR centers simply because there is an ODR platform available. So when I'm able to have that option to migrate from a face-to-face ecosystem to an online world, at least at the ADR perspective, that is a welcome change. How do we view ODR when it comes to courts? Now, courts, Kunchali mentioned that Thailand is on the cusp of digital transformation. Now, court is an area where you cannot replace face-to-face mechanism. You need to have a hybrid, and that hybrid is what will carry forward the digital transformation. Thank you so much, Kunchali. Thank you so much, Thak, for this opportunity. Happy to take any questions.
Thank you very much, panelists. Now we are a bit early for the Q&A, but we have more time. We have about 35 minutes for the Q&A. I have a few questions here from the floor. Let me start by picking one from the floor. This is a question, well, it's for Simon, but I think it probably applies to everyone. But how do you deal with parties who may not be able to afford the resources to conduct online ADR? You mentioned a number of programs other than Zoom that have advanced security protections. But what if one party cannot cover the cost of these programs or does not have the basic technological equipment to conduct online dispute resolution? Guys, do you want to attack that question?
Sure. So I'm assuming this question is targeting more at indigenous populations, low income earners. Like just for the sake of this example, maybe it's a divorce or a separation case, and maybe the husband can't afford it, or the wife or one of the partners can't afford it. This is certainly one of the problems with online dispute resolution. And I believe and I hope that, and when we look to the future and over the coming months and in the coming years, is how can we help to close the digital divide? In the United States, redlining was a popular way for white people to make it difficult for Black people to buy houses. And oftentimes what we're seeing today is there's even redlining for technology. And so this is a systemic issue. This is a problem that is throughout society. And so one thing I would encourage you to consider is, so Legaler right now is having a free deal for ADR professionals. Zoom, you can get the free version. Of course, there's limitations with that. I think Asha brought up a great point. Cybersecurity is always an issue. If you don't have a service provider, then you have to really do your research. You have to go through these test runs, and there are steps you can take. Verifying people aren't in the room, having them send a list, having the client send a list of people. But I guess specifically what you can do is if he or she can't afford the service, you could there may be some sort of public service pro bono legal aid organizations or a library. Libraries in the United States, at least, are some of the greatest access to justice advocates, where a library could offer a private room with a stable internet connection for him or her to participate in the session. So I would consider checking out libraries, see what pro bono or legal service organizations are available. 3, you could potentially consult with the other party and say, here's a loaner laptop if that's an option. And of course, if it's in the United States and they can't afford it, send me an email, and I have connections to people that, could do that. But of course, internationally, consult with maybe lawyer guilds, lawyer organizations, and see if there are some pro bono resources out there. But again, sometimes some of these things are outside of our control. And as the neutral, it's always important to make sure we maintain our neutrality. But there can be some ways where we can maybe provide just the basics so that they are on the level playing field. I think just one thing to add on top of this, what is really important is when you're dealing with potentially indigenous and low income people, is that, for example, virtual backgrounds in Zoom are absolutely critical. Because first of all, if it's a domestic dispute and my background, for example, an abusive partner could recognize this room and they would know exactly where I am. So that's why it's important to oftentimes have a virtual background. You would never use Skype for a family mediation or a divorce or where there's abuse involved, because Skype does not do a good job of protecting people's personal information. So these are the kinds of things you need to keep in mind. And again, you need to always have trainings, participate in things like this. The Thailand Arbitration Center, I'm so honored to be a part of this. They are really on the cutting edge of providing these kinds of services and this knowledge sharing.
Asha, would you like a word on that issue?
Sure, thank you, Kunchali. So I saw this question from Zaina. I'm not sure, Zaina, which country you are based in, but I wanted to echo a few things that Simon mentioned and maybe also take a step back, because there's nothing which says that ODR has to happen on a video conferencing platform. In Hong Kong recently, there was an arbitration that happened entirely over the phone. So that is also a form of online dispute resolution, or not, as long as it's not physically face-to-face. There are ways to get around this. If it's a commercial dispute, you can use, I'm not again sure whether you're asking from the perspective of that you, Zaina, you are an arbitrator or a mediator, or are you one of the parties? As if you're the mediator or arbitrator, then I think, there are a variety of platforms you can choose which are free. Skype is one of them. Zoom is another one. There are many others that are available for free. There's at least, I've done some research, there's at least 12 different platforms that are free and quite decent quality. Google Hangouts, Google Meet, so on. So there are many ways you can do this for free. But if you are the mediator or arbitrator, please make sure that both parties are able to use the platform. And if these platforms are for free, you can get training for free on and learning how to use them. And consider talking to them prior to the session to walk them through the use of the tool, and consider using just the phone. I have used phone plus WhatsApp. Even WhatsApp is another way. Which is possible. I'm just saying that if you use creativity, there are many ways to be able to conduct alternative dispute resolution apart from face-to-face. But just the thing to bear in mind is if you are using a particular platform, make sure A, that parties know how to use it. Do a little trial run, and B, make sure that if there's document exchange, make sure that's done securely. I hope that helps.
Thank you very much for that, Asha. Aditya, would you have some thoughts on that?
Yeah, just one small, thought there on the user experience, because in most of these ODR platforms, we often find that the user experience of the platform comes in very handy if it is from an end user point of view. So let's say if we have people who are from an indigenous background and they need a platform that they can relate to. So the user experience must be absolutely stellar, so that whatever technologies that they've been using currently, like WhatsApp or Gmail or Google Hangouts, the technology of that service provider also must be of similar ilk. Otherwise, it would be very difficult for them to get used to the experience of an online system.
If there's just one more thing I can add as well, and both of my esteemed panelists made me think of this, is one of the most critical things an arbitrator and a mediator should do is have a pre-hearing or a pre-conversation with them. Asha is absolutely right, is that you need to understand what kind of situation your client or the lawyers are serving. And you can do that by first doing a test run of Zoom or using Resolve Disputes Online, whichever platform it may be, or whether it's WhatsApp. If someone's in a really noisy room or there's children around, you are better equipped to handle those curveballs potentially by getting a heads up and by having a pre-mediation or pre-arbitration call with them on the platform that you're using. That's the really critical part. If you're going to be using Zoom, you shouldn't just do a phone call. You should test run the technology, make sure they have the webcam. I love that example of the 360 cam, right? And make sure that user experience is there, that they know how to share their screen in case they're asked to provide evidence. That's really critical, and that can all be covered in a pre-hearing conversation.
Thank you very much for that. I have many interesting questions here, so I have to choose one. From Roland, shall service providers adopt ODR rules, or current rules can still apply to ODR?
So I'd be happy to take that question from Roland. No, I don't think current rules can apply entirely. There has to be an expansion of rules. I alluded to that in my presentation. There has to be rules that talk around or cover things like, how do you ensure there's no witness coaching? How do you ensure there is no recording of proceedings? Because mediations by nature are meant to be confidential, private and confidential. If it's a face-to-face mediation, it's very, it's easier to make sure that it's more things will be kept confidential. If it is an online mediation, then you need to take extra steps to ensure that the mediation or the arbitration will be kept confidential. So there are additional rules that need to be taken into consideration. Some of these organizations have already put out these extra rules. As I mentioned, I also work with service providers to help them ensure that they have all the bits and pieces in place to have a smooth ODR journey. I hope I answered your question, Roland.
Any thoughts from the other panelists? It's a very interesting question.
Asha, she's absolutely right. There are some values and principles that exist in the current rules, but they have to be adjusted. So for example, the ICODR, it's icodr.org. I can also just respond, I can copy and paste this in the answer, but they have a really good, a baseline, what I would call it a floor, where, for example, they just have 5 guidelines for video mediation. It should be accessible, competent, confidential, fair, impartial, and then secure. And of course, it requires more detail and it requires a deeper dive, but generally speaking, those principles should apply to that kind of thing. When you're having an in-person mediation or arbitration, it's almost assumed that it's secure, but it's not as explicit. And that's why it is different, and it requires certain levels of testing and attention to cybersecurity that's been discussed. So yeah, I completely agree with what Asha said.
Buddha, did you have anything to add to that?
Just adding to that, what we need is a comprehensive rule for global ODR providers around the world, like how you've got the ICC rules for arbitration. We've got to bring in all the ODR providers under one roof and say that this is the standards that you've got to follow. These are the do's and don'ts of an ODR system. Because currently what we have is that a fragmented range of ODR providers across the world. So a provider in the US needn't agree to the rules of a provider in Singapore, or a provider in South America needn't comply with the rules based in Australia. So you do have this divergence of self-made ODR rules at this point in time. Unless there is one global organization under which you're able to bring in the rules together, where every ODR provider signs up for those rules, it is going to be extremely difficult in bringing all of them together.
Thank you very much for that, panelists. I have another very interesting question here from Murali, which says, well, it was specifically when Simon was speaking, but I think it probably applies to any of the panelists. In your decade-long career in mediation, under what circumstances have you seen mediation failing? I think the writer means ODR mediation probably failing, and parties approaching to traditional litigation.
Sure. So, I mean, and this is fairly obvious, and this applies to in-person and online. But of course, as someone who's been mediating for a while, when the parties are already dug in their positions and they're entrenched in their views, and of course, that's just one of the hardest things that you can do. When you can't allow them to look at their interests, when you can't allow them to see beyond their beliefs or their values or what position or a certain dollar amount. It's very hard for mediation to work. And mediation isn't the catch-all, the magic pill that can solve all the disputes. Some people just want their day in court. Online dispute resolution and online mediation specifically, it can also fail if the technology doesn't work. And both of my awesome panelists already mentioned this, is when the technology doesn't work, people become frustrated. Lawyers have, and I'm sorry to say this, but have very big egos, and they don't want to admit that they don't know how to use something, or the moment, Simon's computer or internet slows down, they're like, screw this. And, that's very real. You have a lot of money on the line and people are new to this, and people just say, stop. And so it's really important, again, and just to repeat this, to have those pre-mediation Zoom calls or RDO calls or a WhatsApp call to make sure people are familiar with the technology. I've been asked to provide training to big law firms, because if you single someone out as not being good at technology, then they're never going to learn. And so you can, for example, have all of your clients come and just have an introductory course on how to use Zoom, right? So I think that technology failing is a big one. Second, it is really just that unfamiliarity. And the more you can do, and I think DZ, my friend, and I wish we were together in Bangkok. It's so good to see you. But, it's getting people online. And now, as he said, because of COVID-19, this is the moment. People are more productive. People are comfortable using Zoom. And so try to keep people online as much as possible and retain that knowledge.
Thank you. Any other panelists have any thoughts on the question?
Sure, I'd be happy to add a few, chime in here. I think I kind of understand what Murali's question is about. I think he wasn't really specifically mentioning, focusing only on online mediations, but just mediations in general. So when you talk about mediations, there's two, when you talk about online mediations, there's two forms of resistance. One is resistance towards mediation itself, because a lot of dispute resolution lawyers, frankly speaking, not all of them are going to be supportive of mediation because it takes away from their rice bowl. That's a fact. I mean, I can say this, but it's a fact. And then the second resistance towards online mediation is the fact that it's online. So we've covered the online portion already, but let's talk about mediation versus litigation. Yes, to answer your question, Murali, I have seen mediations fail and then head on to litigation, but I would never call any mediation a complete failure. Even if the mediation happened and parties did not agree and they move on subsequently to litigation, parties have at least gone through the mediation process and they've learned to understand the other perspective better. So when they end up going to litigation subsequently, that litigation, at least in the case that I know of, was less painful and it was shorter because parties already went through the mediation process. They already understood what the other party perspectives are and pain points are. There was better mutual understanding. They could not come to an agreement, so they had to go to a judge who would decide for them. But because parties have a better understanding of each other's pain points and perspectives, that litigation did not take that long and it was less painful. So overall, I didn't feel that mediation was a failure. It failed to come to an agreement, but it wasn't a failed exercise. So I hope I answered your question.
Thank you for that. Would Adiya have anything to add?
No, I'm good. Thanks.
Okay. The next question, which I have here, is again from Roland, is that the ICC in Paris was one of the first places to launch the ODR project more than 20 years ago. It didn't pick up. Would panelists have thoughts on why that happened?
I can.
See, I think.
Asha, do you wanna? Or,
No, go ahead. Go ahead. I think I've covered this already, but go ahead. Go ahead.
yeah, I mean, the one quick thing I would say about this is that oftentimes there's this, especially in online dispute resolution, there's kind of just this image or this dream of like what we think the world should be. And we maybe kind of implement it and then it doesn't have the buy-in of everyone. I think the best example of this is Richtvisor, which was a Modria, Colin Rules, and Chitsu's company, one of the first online dispute resolution companies in the world, where the Netherlands wanted to have this online divorce platform. And why, I mean, it's a brilliant idea. If you can meet your partner online, why can't you get divorced online? But it failed to get the correct buy-in with a lot of the judges. There was some question about enforceability, which my understanding of the ICC failure was quite more about enforceability and just a lack of key stakeholders being involved. And it was also very ahead of its time. There was still that belief that when you're online, how can it possibly work as good as in person? And so a lot of these features like Richtvisor and ICC were just very early.
Thank you. Did you have anything to add to that?
Yeah, so I began answering that question. Then I realized my internet played up and we were talking about how technology has to be a very stable one. So, and I kept talking and all I could see was frozen screen at my end and then Simon coming in and sharing his thoughts. Well, as Simon said, one is ahead of its time. But secondly, if we look at the study of technology, there is always a time, place, and the need for those technology in history, if you look at our history. So Possibly one of the reasons why it couldn't take off is because in addition to the buy-in, the timing wasn't correct. Timing even in 2012 wasn't right for many of the ODR players. 2015, 2016, over the last 4 years, we've seen the ODR industry hot up. So timing is one, critical buy-in is one, critical buy-in is two, and the change in the mindset of people, the end users, as well as the businesses and the practitioners. I mean, if practitioners like yourself, Charlie, aren't going to have a change in the mindset, it's going to be very difficult for providers like ours to pitch our solutions in Thailand. So we hope that you will have a change in the mindset very soon.
Thank you very much. We have another question here from Ming, which talks about the context of ODR and the exchange of information and etc. online. And then the question is, how would the agreement resulting from virtual mediation being implemented? So how would it be implemented cross-border? The second part of the question is, would that mean that the mediator, legal representatives from parties have to get the settlement agreement endorsed at their local court? And then the third part of the question is, how would the Singapore Convention on Mediation have a role in the ODR? Any thoughts on that?
Sure, I can take that question from Ming. So thank you for bringing up the Singapore Convention on Mediation. So that was signed last year in 2019. It's been about, I think there was about 46 countries that signed last year, and I think maybe another 5 more have come on board since then. But not every one of those countries has ratified it. So one thing, it's signing is one thing, ratification is something else. So right now, I think Singapore, Fiji, Qatar, Saudi Arabia, and Belarus, these are the 5 countries that have actually ratified it, which means they've deposited their respective instruments of ratification or approval, which means their own jurisdictions have agreed to this. So you're right, in the Singapore Convention on Mediation is similar to the New York Convention on Arbitration in that it allows for cross-border recognition of the settlement or the award. The New York Convention allows for the recognition of the award across borders. The Singapore Convention on Mediation allows for recognition of the mediated settlement. So the whole purpose is to enhance the cross-border enforceability of that mediated settlement. So that businesses, any business that would enter into a mediation and they came and if they have a dispute with another party, they went through mediation and then they have this settlement agreement at the end of the mediation, the business, and this is a cross-border, say for instance, this was a cross-border dispute and they decided to go through mediation, then the businesses would feel a little bit more confident. They would be like, okay, because the 2 countries that are involved, or they have, or say the mediation happened in Singapore, and their businesses happen to be in countries which have ratified the convention, then yes, I'm feeling more confident because the benefit will and the business will benefit from this higher level of certainty because that mediated settlement will be recognized. So so the thing to note is that yes, you have to make sure it has to be contingent upon whether the country in question has ratified it, and let's assume they has, then that's where the benefit of the mediation convention comes, because there will be this recognition, this mutual recognition of the mediated settlement. I hope I answered your question.
Any other thoughts from the other panelists? Nope. Okay, I have a question, my own question. Seeing that we have panelists from all parts of the world, I was just wondering, from your experience, and talking about earlier about challenges to ODR, do you see any challenges that's specific to your part of the world to adopting an efficient system to ODR?
From an Indian landscape, yes. I mean, the legal fraternity is very much similar to Thailand, where people are more keen to get into the brick and mortar model of dispute resolution. They like to go to courts. They like to go to ADR centers. They prefer to sit across and have a dispute resolved as opposed to have an online platform. So it's not only the technology that is important, but the challenge that we face is the shift in the mindset, because we will have to tell them that we'll have to create awareness campaigns. And that's one of the ways that we're trying to build in this concept of omnipresent dispute resolution. People say it's online, but I say omnipresent dispute resolution because it is present everywhere. All we have to do is embrace it as we come along. So that's the only challenge that we face in say, countries like India or developing countries like India, Sri Lanka, and other parts of the Indian subcontinent. Whereas I'm sure in mature economies such as the US, there is a lot more buy-in from practitioners and from attorneys and other players in the market. So happy for Simon to share his thoughts.
Yeah, that's a great observation. In the United States, there are a few different items at play. I would say one of the first ones is there's always been a general, especially I would say in the past 10, 15 years, court systems have been defunded significantly. While there's tremendous amounts of wealth, that, as most people will know, in the United States, we spend most of our money on tax cuts and our military. And our education systems, certain social benefits, and our court systems, our judicial branches, which rely on legislative budgets, are oftentimes left behind. And so while we have massive amounts of wealth, it's just not targeting that. The second and a really key component is that lawyers regulate themselves in the United States. This is one of the biggest barriers of access to justice and kind of almost this generational divide where a lot of people don't feel comfortable online, and they also view any kind of online presence cheapens and or reduces potential money earned, which it's simply not true. You know, you can charge more, you can have more cases online, as Adiya said. I mean, you can be more efficient, you can be more productive. So that's certainly at play. And then the third, and one of the most important, is the socioeconomic divide as well, is that you can't, you know, lots of people still don't have a smartphone or access to high quality internet, and providing those services could be a real, it wouldn't increase justice, it would make justice worse. The United States, I think we're really struggling right now is if we should allow jury trials to exist on Zoom. And it's because of coaching, and it's because of, you know, the racism and the xenophobic and the gender, you know, the sexism that exists. Already there's a bias against a large segment of people in the United States. Putting someone on Zoom is going to exacerbate that, especially when it's a jury trial. You know, there is something to be said about, in a jury trial at least, you know, when you walk into a courtroom and you see the family or you see something like that. So those three things to me at least are top of mind in the United States.
Asha, would you have anything to add?
Sure. Thank you, Charlie. So I would like to add on to Simon's excellent comments. I think he's really hit the nail on the head there in terms of some of the forms of resistance. You know, I've been meeting with resistance to ODR for many years now. Many months now. Well, because the ODR hasn't been around that long. But of course, all of that resistance slowly dropped away and slowly went silent when COVID came. And then, of course, I'm hearing a lot of itchiness. People are desperate to go back to the courts, to have these face-to-face hearings and mediation sessions, arbitration hearings, and so forth. As soon as, you know, the restrictions are lifted, they're thinking, you know, in terms of 6 months down the line, 1 year down the line. And as I alluded to earlier in my slides, I think that, you know, not everything should go back to where we started from. Not everything should go back to the old normal. And also, it'll be very difficult to convince people completely about ODR, but because of whatever you just mentioned, Charlie. But we can use the argument of efficiency. efficiency is what an ROI, return on investment. These are two ways to argue that no matter what happens, even if the virus is handled, the pandemic does disappear. Have a look at what is more efficient. How law firms may not wish to go this direction, but large corporations who have disputes, if they are having a monthly legal bill of several $100,000 US, and that can be reduced by going ODR, then they will not resist ODR that much, because they're answerable to their boards of directors, they're answerable to their shareholders about why didn't they choose the cheaper, more efficient way. So that's one way that I feel arguments might be headed in. If we can prove that ODR is cheaper and more efficient, then why not go that way?
Well, thank you very much, panelists. I think I completely agree with what you've said. Certainly, what you've highlighted in the last question on the cultural and the mindset aspect is very important in adopting ODR, and also the systematic challenges that Simon highlighted. Obviously different systems have their own challenges. So that's for us lawyers, practitioners, it's for us to address, I suppose. I'm afraid that's all the time we have for today. But it's been a very, very useful session. I mean, we went through the concept of ODR. We highlighted the challenges, security challenges, regulation challenges, practical questions of how people can actually access ODR and the mindset behind it. The question of how we can get people to join ODR, how we appreciate the COVID as an accelerator, a catalyst for ODR, but also the challenge of not jumping off the train once it's gone past, how we do that. And how do we weigh up the new norm versus the old norms? Once it's all done, how do we find the right balance of what we are to do in the different legal systems that we find ourselves in? I think these are they're pending questions. So that's why this topic is a very, very hot topic, and I think a very relevant one. So these are questions which I think that we'll have to answer in the very near future as the pandemic subsides. And well, any other thoughts from the panelists? Nope.
Just thank you so much to the Thailand Arbitration Center. It's always an honor, and especially to you, Charlie, for leading such a great session. And of course, to my esteemed panelists, real experts in online dispute resolution and have been doing it for years. It's always a pleasure, and I always learn something new in this, so thank you.
Thank you so much, Charlie, for everything. And thanks, Asha and Simon, for joining in. And Simon, particularly because it's 1 a.m. or 2 a.m. and it's 2 a.m. So
yes.
Thank you so much.
Sleep.
Time for bed.
Just want to echo Simon and Aditya's thoughts. Thank you, both of you, Simon and Aditya. Thank you, Kun Charlie and Kun Banyapa, for hosting the session and for inviting me to speak today. I really appreciate it.
Yes, well, thank you very much again to everyone, and we'll meet each other soon, I hope. If not in person, then through applications like this one. Okay, bye-bye.
Okay, take care, everybody. Stay safe.
See ya. Bye-bye.